So good morning, everybody. I'm Tony Green. I'm Vice President at Ben Franklin Technology Partners, and my colleagues from Ben Franklin, Sri Sridibatla and Kate Srinivasan. And we want to thank you all for joining us this morning in the world of Zoom for a very interesting session that's going to be presented by our colleagues at Fox Rothschild. For those that don't know, PRIMA is a program that we created called the Philadelphia Regional Integrated Medicine Alliance. The acronym came first before the name. And the idea of PRIMA, again, is to help match early stage companies with access to specific and specialized resources. And it's not just about, can I build something or can I get something approved by the FDA, but going all the way back to the beginning about how do you manage building a company, and especially an entrepreneurial company in this world where everybody can work from home, or most people can or not. And so again, PRIMA is a program. We've gotten funding, a grant from the U.S. Economic Development Administration to really flesh out this program. Sri is the point person for this program on behalf of Ben Franklin. And we are also delighted that we have sponsorship. And one of our main sponsors is Fox Rothschild. And so we want to acknowledge them along with our other sponsor, Stradley Ronan. But it's Fox's turn today, and we discussed what kinds of topics might be interesting, especially for early stage startup companies. And one of them is, when do you bring on a full time, and how long do you contract out, and decide what's the sort of tipping point when that happens or it doesn't happen. And so I want to thank Andrew and Fox Rothschild for volunteering to present this program this morning. And we hope that it will be interesting for each of you. Again, use the chat room if you've got some questions. I'll ask Kate and Sri to monitor that. And at this point, I'm going to turn it over to Andrew. Andrew, why don't you introduce yourself, and then let's dive right into it. Thank you.
Sure. Good morning. My name is Andrew MacDonald. I'm a partner in the Philadelphia office of Fox Rothschild. I'm in the labor and employment department in the Philadelphia office, and we deal with issues like this topic all of the time. Whether someone is an employee or an independent contractor. We also deal with all types of labor and employment issues. So, from starting up a company to doing a handbook and policies for a very large company, everything from small to large. So employment agreements, employee handbooks, day-to-day advice, and then also, unfortunately, if you ever get dragged into litigation, we also handle the litigation, any matters like that. If it's a pay issue, if it's discrimination, we really kind of handle employers on employment issues from start to finish, and don't often hand you off to someone if you do get dragged into court. So this topic that we're going to talk about today, contractors versus employees, it is a very interesting issue. It has always been an interesting issue. It's always been an evolving issue. There have been disputes over this issue for the past over 100 years. And interestingly, over the last 20 or so years, there has actually been an uptick, an increase in these kinds of claims in the courts around the country. And you have probably heard of them on the news. The prime example is always Uber and DoorDash and companies that use independent contractors all over the country. And what we're going to do is today is to let you know about what the legal background is, and where these issues come from, how a court or a government agency would look at these issues, so that you are aware. And I'm going to try not to bore you with too many legal cases and concepts. I'm going to try to summarize them in the most efficient way possible, so that you are at least aware of these issues. And if you need, you'll be able to know when it's time to ask the question to someone else about whether you can treat someone as an employee or a contractor, or vice versa. So you'll have a pretty good starting point at the end. At least that's our goal. So let me move into the first slide here. So as in everything in life, there's a choice to make when you want someone to perform work for you. So is this person going to be an independent contractor? Is this person going to be an employee? There's always a risk when it comes to that choice. So there's going to be a cost benefit to this classification of this person who's going to perform work for your company. And you really need to be able to weigh those costs and benefits and see which is the best course of action. That's the overriding theme that we'll talk about today. So let's go through some of the business advantages of contractors. And as you see, there are a lot of advantages of using contractors. Because they are a contractor, because they are not your employee, you don't have to take out payroll taxes. You don't have to worry about the minimum wage. You don't have to worry about overtime. You don't have to worry about lawsuits of discrimination or retaliation. You don't have to pay sick leave benefits. You don't have to pay some other benefits that a New York City or Philadelphia or some municipality is going to require employers to give to employees. You don't have to worry about workers' compensation. You don't have to worry about unemployment claims. You don't have to worry about all types of Social Security, disability insurance, health insurance. They essentially are, if someone is truly an independent contractor, they're performing work for you in exchange for usually just a monetary payment, and that's it. And you don't have to worry about all of the administrative issues that go along with handling an employee. So when you're starting up a company, it's pretty obvious that hiring someone to be a contractor, when you don't have an HR department, you don't have an accounting department, you don't have a lot of things, capabilities in place to handle day-to-day, month-to-month, year-to-year administration of all of these side issues that come along with someone being classified as an employee. Now, of course, there's always risks. So the main risk really comes from someone, either the person themselves or the state government, the federal government, the IRS, saying, you're not doing this correctly. This person is being treated as an independent contractor and they are really an employee. So you have been doing X, Y, Z, A, B, C wrong. You haven't been taking taxes out. You haven't provided them health insurance. You haven't provided them sick leave benefits. There are a very large number of combinations of different types of claims that can come in from, and it's usually a state agency or an employee, or an individual themselves saying, I am actually an employee. So essentially what these, either the agency or the individual will be trying to do would be to undo that contractor status that they agreed to, by the way. It doesn't really matter that they agreed to it. They would be seeking to undo that contractor status, retroactively consider that person to be an employee, and that can cause, to go back a slide, this long list of issues to come back into play. And dealing with that retroactively can be harder than dealing with it upfront. And also, you always have to worry about the IRS or state taxing agencies trying to get back payroll tax or other taxes that you would pay for employees, but not contractors. So the main question is, well, who is a contractor? Who is an employee? Unfortunately, I cannot offer you, no lawyer can offer you a single test, a single question, or even a few questions that will give you an answer. I actually tried to count how many tests, and I gave up because it really depends on each state. There are different tests under each law. So federal, state law, you could have a different test for federal unemployment, a different test for a anti-discrimination law. You could have another test for the state anti-discrimination law. They are all over the place, and there are common themes, but as we'll explore later, you can come out with different results for the same person under different laws, depending on, again, who has raised the issue, whether it's an employee or a government agency that's charged with one specific law. It will depend on what statute or law is relevant when determining if someone is an employee or an independent contractor. And this is a very important point. I wanted to move it up to a slide near the top and not get it buried. Simply because you have something called an independent contractor agreement, and this person has agreed to be an independent contractor. If even that person goes to court, the court will not look at, will not treat that agreement as dispositive. They will not treat that agreement as the answer that the person agreed to. So that person can go into court and say, I am actually an employee. It doesn't matter that I signed this agreement. And it doesn't matter that even at that time, I wanted to be, wanted to be an independent contractor. Whether someone is an employee or an independent contractor depends on the facts, the circumstances, and how that person performed work, and all of the factors that we're going to look at surrounding that performance of work. So there is one test called the economic realities test. And as I mentioned before, I am trying to summarize these tests and not bore you with giant long factor lists. But what the courts do is they use these factor tests. And it's important for you to realize what are the kinds of factors that they look at. So the goal of this quote unquote economic realities test is to really see if this person is their own business, really, if they're independent, or if they have become reliant on your business for their livelihood. And it's a factor test. Factor test meaning a court is going to look at 10, 8, 12 factors, and there is not one factor that is really going to win the day for either side. It's kind of going to be, the court would say, well, 4 factors count towards employee status, 3 factors count toward contractor status, but the 4 ones about employee status are more important than the other ones. So it really doesn't matter that any factors counted toward contractor status. So the most significant factor is control. Again, if you have everything but control, the person could still be an employee, but the courts emphasize that control is the biggest factor. Because again, you're looking to see if an individual is independent or has become reliant on this business to survive. So it matters whether the employer controls how a person does work, using what equipment the person does work, and whether they have just simply the right to control the worker, but they normally leave this person alone. the right to control, even if they allow this individual to just perform their work without really much supervision, can actually be enough to satisfy this test in some cases. So what you're looking at is someone supplied equipment, a computer, a vehicle? Do they have their own, but they choose to use the employer's? Does the employer give this person specific instructions on how to complete their tasks? Does the employer have very hard deadlines of when they have to meet these tasks? It's really, do you give this person an assignment and let them run with it? Or do you control every little aspect of that? So, we're introducing this concept of if you really want to keep control over your company, and you control the people who do work for the company, that is something that's going to tend towards employee status. But at the same time, if you are a small company, you're going to want to maintain control because this is really your passion project in many instances. And are you willing to sacrifice some of those aspects of control to have a task or set of tasks completed by a contractor? So here are some other factors separate from control. And what courts will look at is, is this person doing something that is separate, distinct from the business? And the easy examples here, and that are going to meet a lot of these factors, are, if you have an office building and you hire a plumber. Now, obviously, this example is not that helpful for someone deciding whether to treat an employee at their startup business and contractor employee, but it illustrates the examples here. If you hire a plumber to do work for you, you're not telling the plumber how to do his or her job. You are really hiring that plumber to fix the problem, fix the leaky pipe in your building, and in exchange for money. So that's something that's different than your business. It's not a part of your regular business. You have nothing to do with the plumber's equipment, materials, whether he or she has helpers. The service of being a plumber requires a special skill. It's performed by a specialist, a plumber. That plumber has the ability to make profit or loss based on how well they do. So using the plumber example as an illustration, that person is going to be almost probably in all instances, but you never know, an independent contractor. That plumber is not your employee, regardless of whether he or she claims to be an employee. Now, the only difference would be if you hired that plumber to work at your building every day because you expanded. Now that changes the scenario, and that person could be, after a while, if you really control that person's work, an employee. But for the most part, someone like that is going to be a plumber. So you should start to ask yourself a question if you're considering someone to be a contractor. Is this person hired to do a discrete task that is separate from my business? And we'll explore what my business means a little later. But is this person a plumber, or is this person someone who could very well be my employee? Now, before we move on, I just want to note a few other tests. So aside from the, quote, economic realities test, which is used in a lot of different statutes. So the IRS uses a 20-factor test that has 3 different categories. And I did not want to bore you with every single 20 factor in this test, but they're really looking at behavioral control, financial control, and the relationship. Like how much can you control this person's work and their behavior at work? How much financial control and reliance does this individual have on the business, and generally what kind of relationship do they have. And then just another example where it's a little different, the National Labor Relations Act, which deals with employee unionization, because only employees can form unions, not contractors. They look at whether the National Labor Relations Board will look at whether an individual has really, we mentioned this before as one of the factors in the other test, but whether this person has the entrepreneurial opportunity. Can this person make more or less profit by doing more or less work, or better or worse work? Is it really in their hands to perform work? And under that test, for example, it wasn't the labor board itself, but its general counsel in an opinion memo, as an example that everyone should be familiar with, found that Uber drivers were contractors under the Labor Act, so that they couldn't bring claims related to unionization. And essentially because they controlled their schedules and could do more work or less work. And it was really on them to have that entrepreneurial spirit or not, to be able to make more or less profit. So those are some of the other tests that can pop up. Now, this next test, and I promise this is actually the last test I'll talk about, but it is extremely important because this is a state law test. So it matters where, even if under a federal law, say an Uber driver who has been found to be a contractor under the Labor Act, has nothing to do whether a state could find that that person is actually an employee and you all these payroll taxes on that person. So this ABC test is the most restrictive test for employee versus independent contractor status. It is present in New Jersey. It's actually where it started. The ABC part of it, the acronym is not really an acronym. It actually comes from the name of a case in New Jersey. But Massachusetts has adopted essentially the same test by a law about 10 to 15 years ago. And in California, about 2 or 3 years ago, the California Supreme Court ruled and adopted this ABC test that is the most restrictive test with employee contractor status. So what the law does, it presumes that a person is an employee unless you show that the person is actually a contractor. So if you can't show that the employee is a contractor, the person is automatically an employee, and the person starts off as an employee. And you need to show 3 things, which is where the ABC comes from. First, control. We've already talked about that. So we've got that covered, but the other 2 factors are very important here. So the individual has to perform work outside of the regular business of whoever is doing the hiring. So, if you are a startup concentrating in a, let's say a delivery service, that person, it's very questionable if they are doing the deliveries that they could ever be a contractor. It has to be outside of your regular business. So that's why a lot of times you'll see creative arguments that, well, my business actually isn't delivering products. My business is the logistics network that enables people to go and deliver things for me. And so the next factor, the last factor, is whether the individual is engaged in a customary trade or business. That brings you back to kind of the plumber example. A plumber is a customary trade or business. A taxi driver is a customary trade or business, but it becomes a little gray where it's just someone delivering products. So if you don't, and I said the word factor a moment ago, it's actually not a factor. These are the 3 things that must be shown. So this is not a weighing of different factor test. This is, if you don't meet the last prong, then that person is an employee, even if you've shown that it's outside your regular business, and even if you've shown that the individual is doesn't really have any control from you as a business. So this is very important to be mindful of. Pennsylvania at this moment does not have this test, but New Jersey does. And it's really a state by state question. So I've been mentioning this over the course of the presentation, but you can have different tests can lead to different results. So my example here is that someone could be a contractor under overtime law, the Fair Labor Standards Act, but they could be an employee at the same time under state law if that state has, say, the ABC test. So if that person sues you for overtime, you might win that case because they're a contractor, so they were never owed any overtime to begin with. But at the same time, if the state of New Jersey did an audit, which they commonly do, of your records, they could find that all of your employees or all the individuals performing work for you, not just that one person who sued you, were employees, and they want you to reclassify them as employees and pay all the taxes that you didn't pay to the state of New Jersey. That's just an example, but that's something that can happen where these people are doing the same duties, and it could even be about that same individual. The fact that one court under a federal law has found someone to be a contractor doesn't matter under either another federal law or under a state law. So that was the main part of this presentation about contractor versus employee. So and we're going to have questions at the end. That is one of the most important issues that you're going to, or have maybe already confronted when starting up a business. But I wanted to take the rest of the slides here to talk about a few other issues that are related and can come up around the same time that you're considering employee or contractor status. So, if you're in a small company, there could very well be an overlap of titles. So you could be a shareholder, a director, an officer, and also an employee, all at the same time. The distinction here can matter whether you can be held liable, whether the entity is covered under, say, discrimination law, like in Pennsylvania, the state anti-discrimination law, the Pennsylvania Human Relations Act requires a business to have 4 employees for coverage. Well, if you are the director and an officer and a shareholder, but maybe also an employee, do you count as to that level? So if you have 3 other employees, do you count, and have you met the 4-person test, or do you not count because you are essentially the owner of the business? And unfortunately, different laws have different results here. And I'm going to give one example of a case that arose in Pennsylvania. And this was under a federal law. And this person was, like I just said, an officer, director, shareholder, and an employee with an employment agreement that said he could only be fired for cause. He tried to sue his family business for religious discrimination. And the court said, because he was an officer, director, and shareholder, and he had actually exercised control over the business, the direction of the business, what kind of work the business is going to do, he was not actually an employee, even though he had an employment agreement under the Title VII is the Civil Rights Act, and it prohibits religious discrimination. Under Title VII, he was not actually an employee, so he could not actually sue the company. So if he was, in my example before, if you're trying to see if you get up to that 4-person limit, he would not have been considered to be an employee, and that business would not be covered by that statute because they'd only have 3 employees and not 4 employees. So this distinction between an overlap between officers, directors, shareholders, in law firms, could be partners or other types of accounting firms, different businesses that use the partnership model. Those people who are classified may well not be employees, and that can matter a great deal whether you can sue or whether the business can be sued. So it is another thing to think about. So when you're dealing with these issues of whether someone's a contractor, an employee, a director, but also an employee, understand the distinctions and why these things are there. Someone is a director because they are on the board of directors, and they are really one of the people who run the business, are in charge of the business, have to be if you're a corporation under state law. So it is not as if you just can't have a director. You got to have a director, but you've got to be mindful of whether that director is someone who's not involved in the business. Maybe they just invested money and have a seat on the board, or are they doing work? Are they also an employee? And maybe under certain circumstances, if they don't have much control, they could also be a contractor. It's very unlikely that that could be the case, because someone who is a director could actually have control over themselves. But there could be, you can't try to ignore these distinctions and kind of hope for the best or try to operate without employees because you're all directors. Well, if everyone is a director and they're performing work, then they're probably also an employee. And reminding again, an employment agreement essentially in this area does not matter. If it's an employment agreement, if it's a contractor agreement, whatever you write on paper, if it's different than the facts on the ground, then it's really not going to matter, and you cannot rely on that. It can be one of the factors that's looked at, but it is not a very strong factor. And so essentially what you need to do is keep track of these individuals' work and status within the company. They may start off as a contractor, but if you give them more tasks and you give them equipment to use and you control what they're doing, and that expands over time, then that person could become an employee rather quickly. And you need to know when it's a good time to change their status. So that leads into this slide about conversion. Can you convert a contractor to an employee? And it really depends, but yes, and it depends on what they're doing. You need to be mindful that if you convert an employee or a contractor to an employee, you're not going to undo their status if it was improper in the past. So it can't fix things in the past generally, but you're going to start the clock on employee status and prevent that from getting worse over time. So if someone is really a contractor or really an employee but has been treated as a contractor, and you convert them today and they've been working for you for 2 years, you're not going to be able to reach into the past and fix it retroactively. Unless you want to admit that you didn't pay all the taxes and a lot of other things that could come with employee status. So, but you're going to stop any possible harm that, if they sued you a year from now, you would have only 2 years of exposure if that person was really not a contractor instead of 3 years, because you converted them 2 years in. So those are things to be mindful of too. Another topic here that was included that some people wanted to discuss was really keeping control of your work. And this is a kind of a secondary thought, but it's a very important topic here because contractor and employee status can actually matter a great deal with these things. But just with any other aspect of business, attention to detail can be very important. So when you bring someone on, it is really good to make sure you define, it's a best practice, who owns the work, who owns intellectual property, what kind of information is confidential. If someone invents something while they're working for the business, who owns it, and who owns, the laptop, who owns other property, who owns passwords, really, to systems that this person might access, and does that person have to return it when they stop working for the business? So it is always a good thing to have these issues defined in writing. You really need to be mindful of where this person's coming from. If they are coming from a university or a former employer and they've done work in some area in the past, they might not be the owner of that work. They may not be able to bring that work product over to your business. And if you allow that to happen without really checking, or if you allow that to happen while purposely kind of closing your eyes and sticking your head in the sand and kind of saying, I don't really want to know, that could lead to problems in the future. So there was a lawsuit a few years ago, Google versus Uber, about their autonomous vehicles and whether this individual had come over to Uber from Google and had brought with him certain trade secrets and other confidential information. And I believe it ended in a settlement, like most cases do, but there was very heated litigation for some time. And the question was really whether Uber knew that this person was bringing over information or not. And it's just not a battle that you want to have if you can avoid it up front and have people disclose. They can have, in a written agreement, you can have someone disclose what work they own, they claim to own, or that they're responsible for, or that some work that they might be restricted in doing for your business. And then also, in the spirit of keeping control of work, you also want to make sure that, say you're using an independent contractor, you hired a specific individual, and then you find out, well, he actually assigned it to someone else. Well, did you have a written agreement that said that he alone could do that work, or could he assign it to someone else? Or are you engaging a company where you don't actually really have control of who is assigned that work? These are things that you can spell out in advance so that you know who's doing the work and that you can keep control over that. And then also make sure that work and expectations are clearly defined. Now, this could be important because if a dispute over one thing can lead to a dispute over a more important issue. If you have a dispute over a deadline and it becomes very heated, and maybe you don't pay this contractor and he's been doing work for you for a while, maybe he claims he's an employee, and maybe now the light dawns on him that he should file a lawsuit, and there's bigger issues at stake than just this one dispute over one project. So it's always a best practice to get those issues, get ahead of those issues, and make sure they're addressed, preferably in writing, beforehand. And lastly, this is my legal disclaimer, and it's almost 10:45 now. And so we have about 15 or so, I can stay later if needed, minutes for questions, if people have questions in the chat board.
So yeah, first of all, Andrew, thank you very much for that presentation. And it's always interesting how, no matter how much you think you understand the block and tackling of getting a company up and running, and the continuous monitoring that you need to do to make sure that you don't let these little landmines, cause problems for you down the road. So I want to thank you for those insights. And now, again, Please use the chat room, and or if it's not there, then just jump in and ask Andrew some questions. So it looks like we've already got some questions. So Andrew, I'm going to let you jump into the chat room and start to go through some of these questions. Thank you.
Sure. Yeah. So the first question I got is a very, very good one to address. So which is the governing state, my company state or the contractor state? It's going to be the contractor state where that person is performing work. And that is going to be very important, especially in this day and age where people are telecommuting, working from home. Where is this person doing work? And can it get even more complicated if they're jumping around and working in different places? It's going to be where the vast majority, substantial amount of work is being performed. So if you're in Pennsylvania and someone's in New Jersey, which, I am in the Philly office, but I'm coming to you from Collingswood, New Jersey. If that person's in New Jersey, you're going to have to worry about that ABC test. You have to worry about that stricter independent contractor test because they're doing the work in New Jersey. They are subject to that state's laws. This applies for employees as well, not just contractors. And you're going to have to assume that the law at issue is going to be where that person is. So another thing to worry about is, we didn't talk about this today, but non-competes, you might be aware, they're generally prohibited in California. If you engage someone in California to do work for you and you try to have a non-compete on that person, it's not going to stick because that person is doing the work in California, subject to California's law. And Massachusetts also has a stricter non-compete law, and you need to assume that if you're engaging someone out of state, that other state's law applies to that person. All right, the next question, the 4-employee threshold. So that is just one example of a law that has a pretty low threshold of employees. So federal anti-discrimination law, Title VII, the Americans with Disabilities Act, has a 15-employee threshold. If you have 14 employees, then that law does not apply. If you have 15 or 16, then it does apply. So, if by the time you have 15 employees, you're a decent, you're not a just startup company. So you probably should have the ability to deal with some increased exposure to liability. But under some state laws, like Pennsylvania's anti-discrimination law, the Pennsylvania Human Relations Act, it only requires 4 employees for coverage. So you could hit that very quickly. If you're a startup and you have 3 business partners and you're all doing work and you're all employees, that could very well have one of those business partners could sue you under that law. Or you could litigate it for a while and none of those people could be deemed employees because they were really owners of the business. But that magic 4 only applies to that one law. Each law really has their threshold of employees. Some states like New Jersey like to just apply a lot of their laws, not all, a lot of them, to any employer regardless of status. But so that 4 employee count is specific to just that one example I gave of the Pennsylvania Human Relations Act. And that's something that you should take a look at if you need to. I have a second for the first question. All right, so here's another question. If you are a Pennsylvania operating company but have an individual in an ABC test, would that test apply only to that individual? Yes. So it wouldn't really become a contagion from that one person through the whole company. It would only apply to that one person. So if you have contractors all over the country, if you hypothetically had contractors in every state, you would have 50 different rules and laws to look out for of whether you could classify that person as a contractor or an employee for that person. That won't spread throughout the company if for some reason you have a person in, say, New Jersey or California, where there could be a more restrictive test. All right, so here's a question about control, and this is a really good question. You know, in a highly regulated industries, businesses must have procedures to control the work, which is understandable. And if a contractor must perform the work according to these procedures, is this considered control over the person's work or controlling their performance? It's really kind of a control over both. It's controlling their performance and their final worked product. And there are scenarios under these legal tests where a company can say, I wasn't the one who controlled. It was this regulation, really, that forced me to tell this person they have to do the work in a certain way. So I, the business, am not exercising control over that person. It's really the law that's telling that person that they need to do it. I'll tell you that works sometimes, it doesn't work in other times. So, you know, a high level example, which probably doesn't apply to most of these companies of people that are here, but, you know, the trucking industry has a lot of independent contractors, owner operators of trucks, and they have to follow CDL guidelines, you know, DOT guidelines for their license, and, you know, they're transporting fuel or explosives. The company that engages them is not telling them that they have to do that. It's the law that's telling them that they have to operate certain ways, drive on certain roads, you know, don't go over the certain bridges, things of that nature. It's really the law.
Fox, which loyally orbits planet Trump. There's a new.
I think we've got someone. Oh, there we go. All right. Next question is, if an employer has a very short-term project, maybe 2 weeks, needs to dictate to the person what hours they need to work, meetings to be a part of, would that employer have to treat this person as an independent contractor or employee? So simply because it's 2 weeks, if it's 1 day, if it's 3 hours, the time doesn't matter. So it's really going to matter how much control is over that person, and then weighing the other factors here. So an example here is why companies use temp agencies. And just to put another spin on this, is that a temp employee is usually the employee of the temp agency, who is then shared with the entity that's getting the work performed. So where there's another employer involved, then you generally can avoid the contractor employee issues, because that person has another employer, and you've engaged that temp agency as a contractor to supply you with work. And that temp agency is not in your business. That temp agency is in its own business of being a temp agency. So, you know, short-term projects, if that's a real concern, it can be done by someone who can have another employer tagged to them, is usually beneficial. But simply because someone is hired for a very short duration is really just not going to matter. It can be part of these factors, but it is not going to be a significant factor if you have complete control over that person's work while they're there. Okay, message that we are going to upload the presentation on the website. I have a question with a specific business, so I'm not sure I can really answer that one. But so the next one is, jump down to the next one. Is there a difference how location of employment is considered for contractors versus employees regarding, you know, local taxes like the Philadelphia wage tax? How about when the employee is or not working remotely? So, you know, this is something we're all grappling with. And I mentioned before, I'm in New Jersey. I used to commute every day to the office in Philadelphia. I won't say exactly how they're treating me, but generally it's going to follow the person. So if the person is now in New Jersey full time, or just outside of Philadelphia, that person would, and is performing work completely outside the city, that person is generally not subject to the Philadelphia wage tax. And this is a big problem for the city, and the fact that they rely on this wage tax for their revenue. There's going to be a dramatic drop off in it. But even before the pandemic, there was, and this is just from my own knowledge, a form you could submit to Philadelphia and say, I only worked in Philly X amount of days, and they can sometimes accept that and sometimes not. You know, if you were a salesperson and you were always commuting outside of Philadelphia, it would behoove you before, pre-pandemic and now, to look into something like that, where you know, that you would be not subject to the Philadelphia wage tax if you weren't working there every day and you didn't live there, because I know Philadelphia also taxes residents under that tax. But for tax purposes, for employment law purposes, the general rule, and again, there's always exceptions to this rule, and as any lawyer will tell you, non-tax lawyers don't give tax advice, but the general rule is follow the employee. Where is that employee working? And that's usually going to be the answer. And understandably, that can be very complicated at this day and age with teleworking and Zooming, but where is this person physically located is the general question. All right, next question. I think we have a few more minutes. Yes, we do. If a company maintains quality assurance over contractors' work for a client to ensure the client's expectations or needs are met, is that an example of controlling the contractor? So yes and no. So you can make sure that the final work product is up to your standards. Going back to the simple example of a plumber. If the pipe is still leaking after the plumber said that he or she fixed it, you know, that's your quality assurance check. That person's not an employee because you say you didn't fix the pipe. You need to come back and do it, or whatever the case is. So just quality assurance is not going to lead to control over that person. But in order to get quality assurance, did you give that person a 10-page list of how to do that work? So you're getting ahead of yourself. You're not checking at the end or just kind of checking in as it goes, but did you, in order to get that proper work product, did you really control that person as they did the work with all types of guidelines of this is how you do the part 1, this is how you do part 2, this is how you do part 3. If that control over the work is very strong and powerful over that person, and they really aren't allowed to do their own thing, then that person could tend toward employee status.
All right.
So I think we're at the end of the questions here, unless I missed
I
something.
think it worked out perfectly.
Yes.
Again, Andrew, thank you very much for your time this morning, and thanks everybody for joining the session this morning, and hope it was helpful and useful. And you're going to see more of these coming from workshops being sponsored from PRIMA and of course from Fox Rothschild. And again, appreciate everybody's time this morning. Be safe. I'm going to go out and get my snow blower and deal with whatever the hell's out in front of my house. So everybody have a great, safe holiday, and look forward to seeing everybody again soon.
Yeah, take
Andrew,
care.
again, thank you.
Thank you. Thanks for having me.